Hi, everyone. Welcome to the fifth week of the Florida Bar Crash Course. And we have already gone over the four foundational subjects, which are contracts, torts, con law, which is federal and Florida con law, and real property. To me, those four subjects you want to make sure you know and you know well, because some arrangement of those four will be tested. Now, as we move on to the second half of the course, we move on to some of the essay subjects that aren't as heavily tested, which include family law, which include trusts, which also include commercial paper, secure transactions, and then we'll finish up with ethics. But before we move to secure transactions, commercial paper, and ethics, we're going to do the multiple choice section, which is a brutal, difficult section that we need to be super locked in. That's what's going to happen over the next 2 weeks. But this week, we're going to do two of the essay subjects that I think are manageable. In particular, trusts. I think if you get a trust essay, you should be happy because it's pretty standard. You know, if you know the elements of the trust and how to create a trust and what are the duties of the trustee and some things like spendthrift provisions, like there's a couple things to know, but overall, as Will is going to explain, there's a standard outline where you can just identify the trust and go through the outline. Family law gets a little bit more chaotic, but it's usually the best interest of the children. It's going to be a divorce. It has some elements of civil procedure and how far away you can be and who could bring the proceedings. And then there's elements of alimony and child support, spousal support. You know, there's a lot of little intricacies of it. I had a discussion with one of my students about why real property, in my opinion, is the hardest subject. And I said, because it's the most, to use the same word, chaotic. There's so many different ways they could test it, and it's not straightforward. Contracts are like, go through the validity of the contract, you know, body of law, contract formation, defenses, breach, damages, look for auxiliary issues. Torts, identify the torts, and then, you know, just give arguments for them. Con law, you can kind of look through a federal lens. Have they been deprived of constitutional rights? And then look through a Florida lens and apply the elements, you know, of the Florida Constitution. Real property can be all over the place, right? Is it a mortgage? Is it a landlord-tenant thing? Is it a deed? Is it, who knows? They could throw the rule against perpetuities at you. It could really be, and there's always a lot of parties. It's convoluted. There's conveyances. There's notice statutes. Real property is tough, and you just want to take your tools and be like, I know we're pure notice. I know we're lien theory. I know the deed formalities. If I see the issue, I'm going to write about it and try to get my points. If I were to compare family law and trust, I would say trust is more like straight essay. Like I said, you just know what to write about and you can write about it. Family law, you do have to identify, you know, what it is. It's not always the same thing, so you have to be prepared with these different tools. We had a fun little game where we gave ourselves names and albums. My name is Ill-Gotten Gains, and my album is Restitution, because we all know the purpose of restitution is to disgorge ill-gotten gains. Will had a name, but I told him it would be most professional to go back by Professor William. So Will, without further ado, I'm gonna make you the host, and you can start the first lecture for today, which is gonna be on which subject?
We'll do trust first.
We'll do trust first. That's what I was hoping for. All right.
Awesome. So hello, everyone. Andrew gave me a little bit of introduction, so I won't waste your time going over that anymore. But suffice to say that I was a student with IBIS Prep. Actually, almost exactly a year ago, I was in this exact spot you guys are now, doing the exact same thing you guys are doing now. And this is actually what I did when I was studying with Andrew. I made these kind of cheat sheets, which I've now made into a PowerPoint. And as Andrew said, I firmly believe that you can memorize this cheat sheet, and this is what I did on the bar. I had trusts when I passed the bar.
Well, just to stop you, because this happened with me, you have to stop sharing your screen and then reshare, because right now we just see loading. We don't see your PowerPoint. I don't know why this happens. Yeah.
Weird.
Yeah.
How's that?
Perfect. Easy.
Awesome. Thank you. Yeah, so I firmly believe that that you can memorize this cheat sheet, and then literally every single trust essay you ever get, will ever see in your entire life, you can literally, without even reading the facts, write this essay down, write this cheat sheet down, go and read the facts, and you just add a couple facts in, and you'll get a really, at least a passing essay, if not a really good essay. And that's exactly what I did on the exam. I memorized these cheat sheets. Like Andrew said, for those four that you guys have already covered, they're kind of more, they vary. It's kind of hard to nail down exactly what you're going to see. But for trust, secure transactions, family law, commercial paper, ethics, you're going to see the same over and over again, the exact same things. And so, without further ado, we'll just jump right in. The golden for trust is valid trust don't ruin marriages. And I didn't come up with this. It might have, Sam, was this you that came up with it when we were going through together? I don't know if you're still there, but it might have been Sam. Another student came up with this while I was studying for the bar. And
I'm here, but no, it wasn't me.
It wasn't you? Okay, I was trying to give you credit, but okay, it was someone else. But valid trusts don't ruin marriages. So the valid stands for validity, pretty easy. T stands for the types of trust, pretty easy. D stands for duties of a trustee. R stands for removal of a trustee, and M stands for modifications of the trust. We'll go through all those individually. But if you just remember, valid trusts don't ruin marriages, makes it very easy to remember everything. This is everything you will need to write about on a trust essay. So really good stuff. And I just straight memorized this. I definitely think you should too. We'll just keep going. So the first step is validity. Valid trust don't ruin marriages. Valid is first, validity is first. So what makes a trust valid? It's valid when it has property, and property has to be current ownership in a thing. It can't be a future interest. So if you have a current life estate, that's good. But if you're a remainderman on a life estate, that can't go into a trust. Once that remainderman vests, then you can have a trust in that property. But you can't have future interest. So for instance, you cannot make I know one of the things we talk about in another topic is how you can use potential gains in a ongoing lawsuit as a form of property. I think that's in secure transactions. We talk about that. Regardless, because that's a future interest, you wouldn't be able to make a trust out of that future gains in that lawsuit. So that's important for the property. And so they'll try to do that all the time. They'll be like, they have a future interest in this thing. They won't say future interest, but they'll say, Chrissy is named in her uncle's will. Can Chrissy put that property that she's going to get in her uncle's will in a trust? No, she cannot, because she doesn't have a current vested interest in it. It has to be a trustee in the state of Florida. They have to be 18 and a resident of the state of Florida. Beneficiary can be anyone, but it has to be a readily verifiable person. So it can't be a kid, it can be my kids, but it can't be my friends, because, you can make an argument for my friends, but it's unlikely to be my friends. You can always make an argument about everything. You should be making arguments about everything. But my kids is easy, right? You can do a DNA test and you can prove who my kids are. But my friends, I like them, or was I just being nice? Like that. It's hard to tell who my friends are, especially after I'm dead. If the trust is made inter vivos, it might be easier. What have you? You need verifiable beneficiaries. And lastly, it has to be in writing for certain trusts. Basically, the statute of frauds applies. So if it's, if any of the statute of frauds apply to my legs formula, if any of the my legs applies to the trust, which a lot of times it's not. Although, sometimes you can make a trust because someone's getting married, right? Like that could be your gift to someone if they're getting married, is that here's a trust for you. In that instance, you might want to argue that statute of frauds would apply. It's debatable that it wouldn't, but it could. And then finally, if it's less than $500, if the value of the property is less than $500, and remember, the value of the property, so you can make trusts for anything, right? You can make trusts for sentimental things as well. So a sentimental thing, if you make a trust, let's say I made a trust for the blanket my aunt knitted, my wife and I, when we got married, and it's very sentimental to us, and all of my nieces and nephews fight over it because they want to own this thing. So I built a trust. I put the trustee in charge of it to make sure that no one would ever hog this blanket. Is that stupid? Yes. Is it something I can do? Yes. that thing be less than $500? Yes. Therefore, it has to be in writing in the state of Florida. Another thing that this is a Florida specific law. I mean, a lot of this is Florida specific law, but make sure when you say, obviously statute of frauds is not Florida specific, right? That's a grander MBE style law, but make sure when you're saying things that are only Florida specific, make sure you say the words in Florida. They really, I mean, that's, graders have like wet dreams over the phrase in Florida. So make sure that you are saying that whenever you get to something that's only specifically in Florida. So that's validity. We'll have questions at the end, but if there's any specific questions about validity of trust, we can stop briefly.
What I'll just say to clarify is that trust in Florida is one of the few states that does recognize an oral trust, but generally they should always be in writing. And the rule here is that if it's for land, it needs to be in writing. I just remember that. All right, yeah, good stuff. So validity, is a trust valid? Does it have property, valid race? Is there a trustee? Is there a beneficiary? And intent, right? Settler intent. They have to intend to do it.
Right.
I have a quick question.
Yeah.
So just about that, the less than $500, because obviously in the regular, I guess, federal statute of frauds, goods over $500 will necessitate.
Right. So I think what Andrew said is probably better. It's primarily about land. I don't
want you guys to get confused with that statement. I think that's not clear statement or necessarily correct. Just know trust can be oral in Florida, but if there's property, then it needs to be in writing. And don't worry about the UCC law. I don't think that actually applies. But
not sure where I found that. I'll change this PowerPoint for next time.
No
yeah. So yeah, remember that if it's less than $500, it has to be in writing, or if it's about land, it has to be in writing. Those are the two rules. And then, so we get to my favorite, and I think Andrew's favorite, because I think it's actually his least favorite, but he loves it because he hates it. And so this is the types of trust. Précédent is the I use to remember every type of trust you could ever be tested on. And so I'll go ahead and try to remember them all. So it's testamentary, resulting, revocable, irrevocable, spendthrift, inter vivos, discretionary, oral, no contest, charitable, spendthrift, and then there's a secret S on the end, which stands for secret trust. And so that is all the types of trust you can need to go through. Testamentary is created in a will, needs will formalities, so that's when you go back to the will formalities you study under go ahead, Andrew.
That's another point. When does it also need to be in writing? If there is property, or if it's testamentary in nature, because wills have to comply with will formalities, which you're about to see are. Are you about to click? I thought you were about to click it. Yeah,
sorry. Must be in writing and signed at the end by the testator or another person who subscribes to testator's name. Yeah, I mean, this is the stuff you would study under wills, but yeah. So in this case, it would need to be in writing. So this is an instance where oral would not be a valid will. Awesome. A resulting trust happens when a portion of the trust fails. So this would be when a trust, and we'll get to modification at the end, but when modification occurs, when a trust fails because of changing circumstances or because what have you, whatever reason, potentially they run out of property in the trust, the court will try to save the trust by creating a resulting trust. They'll kind of change the trust, and the result is a resulting trust. A revocable trust is a trust that can be revoked or amended. So this would be a trust that is made inter vivos while the testator is alive. And the thing you have to remember is that a lot of these things can be, you have two types of trust in the same trust. So a revocable trust can also be an inter vivos trust. They can be the same thing at the same time. But so this is made during a testator's a settler's life, and a later will or codicil or something changes the trust. And so, or the testator themselves can say, you know what, I no longer want to hold this trust to this reason. I want to revoke it. I want that property back. And so, important because at this time, settlers, if it's revocable, a settler's creditors may reach trust assets during the settler's lifetime. So if I make a revocable trust, it's not protecting it from my creditors. They can get to it. My debtors can get to that the res of the trust, which is important because we can get to irrevocable. It's the exact opposite. You can't ever revoke it for almost any reason. There's obviously going to be some loopholes sometimes, but generally, irrevocable trusts can never be revoked, and creditors can't get to the assets as attachment. You can get to, however, you can get to payouts. So, irrevocable trust allows for, you know, certain payouts at certain times. Well, they can immediately attach. My debtors can immediately attach to those payouts. So they can't get to the res, but once that payout happens from the res, they can get to that payout.
One thing I want to mention too is in Florida, does anyone know, are trusts presumed revocable or irrevocable?
They're presumed revocable.
Presumed revocable. Now, if you want to make a trust that's, you know, really hard to pierce, what should you make it? Irrevocable. Like, that's kind of the way I think about revocability versus irrevocable. It's revocable assumed, but like if you're really trying to protect the trust and the property of the trust, it's better to make it irrevocable because of these conditions that Will was explaining. It's harder to pierce an irrevocable trust. So just remember that statement, that in Florida, trusts are presumed revocable unless explicitly stated otherwise.
Yeah.
And another thing that I always remember is the hallmark of trust creation is settler intent. You know, what did the settler want to do? That's what we're trying to think of. Did he want to create a revocable trust? Did he want to create an irrevocable trust? Or did he want to create these spendthrift provisions? And these are very, very important. When we're going through the, you know, buzzwords of trust, major buzzword coming up right here, spendthrift.
Yeah.
So what's that, Will?
Yeah, spendthrift is basically, so whenever I think of spendthrift, my property professor taught it like this. He indicated, imagine you're a millionaire and you've got a nephew that you want to give money to while you're alive, after you're dead, whatever. But you know your nephew is a gambler. Yeah, he's awful with money. He spends his money everywhere. You know he's just gonna immediately spend it all, and you're very afraid of him doing that. So what you might do is you might put a provision in the trust that specifically says that creditors and creditors of beneficiaries can attach the payouts of the trust until the payment has been made to the beneficiary. So what that means is that they can get to it once it's in their bank account, but until it's in their bank account, they can't get to it. And spendthrift trust is very powerful. And we're actually going to skip one of the chizidongs, but we're going to get to discretionary. It's very powerful, but it's more powerful when you combine it with discretionary. Because like we said, they can get to the payment, right? So once it's in your nephew's bank account, they can get to that. What that means is if your trust says, you know, payments have to be made every third Thursday of the month, your nephew's creditors are going to know it has to happen every third Thursday. We're just going to take it every third Thursday. We're going to get that money every third Thursday, whether he likes it or not. If you make it discretionary, which means that the trustee gets to decide when payments happen, they can't force you to make payments. So let's say Andrew is the trustee of a trust to my nephew. And I tell Andrew, you have to make payments every third Thursday. But Andrew knows that my nephew has a lot of debtors. The debtors can actually sue Andrew to force him to make the payments every third Thursday. He has a legal obligation to do that. But if I tell Andrew, you make the payments whenever you think my nephew needs it, well, then Andrew can do, you know, whatever, you know, legal, accounting he can do to confuse those creditors and make it so they can't get to those. You know, maybe he sends it to the Cayman Islands first or something. You know, he can do stuff. He can do things with that money to make it less attainable by those creditors. So spendthrift and discretionary, very powerful together.
I like that. And I don't know if you were in my class. I don't think so, because it was summertime, because I remember it was his song. But I used to refer to Tom Hanks's kid, Chet Hanks. Was that his name?
Yeah.
What's his
Chet. His name is Chet.
What's his rapper name? He has one too.
White Boy Summer or something.
Yeah, what was it?
Yeah.
think he's like this is like a hot boy summer or hot white boy summer.
Chet Hayes, White Boy Summer. That was his name and rapper. Terrible. We have some good names in the class, like mine, Ill-Gotten Gains and Restitution. And one of my favorite names is Attractive Nuisance and her album Broken Trampoline. So we're having some fun here in class. But this is good stuff. Trust. First thing, identifying is a valid trust, and he went through those elements. And then what type of trust is it? And he gives you this acronym TRUSTS. Testamentary, it's got to be in writing because it complies with the will. Also, if there's real property, it has to be in writing. The resulting trust, revocable, presumed in Florida. Irrevocable is a way to make it so that there's no way you can revoke it. It has more protection. And then if we're talking about great protection, spendthrift provisions, so that Chet Hayes can't, his creditors can't attach to the corpus of the trust. They have to wait until the distributions. And then I love what Will was saying here. Discretionary too. That's a tool so that the trustee has discretion when to give the payments out. So he's not going to give them out to Chet to drop his new mixtape if he doesn't see the promise in it. So I'd never thought about that, the power of combining discretionary and spendthrift. Is everyone good with these types of trusts so far? Any questions in the audience?
So if you have a property that's in the trust, and say a property is given to the gambler nephew, but it's not a payout. So if it's a property if the trustee buys a house with the money instead of an actual cash payout, are the creditors allowed to go after or attach that house?
Yeah, that once if it's as long as it's in the beneficiary's name, they'd be able to go after it. The trust can retain ownership of the property and allow the beneficiary the ability to stay there. But if it's in the beneficiary's name, they're going to be able to attach to anything that's in their name.
Okay.
But
Gotcha.
what if it's Florida and it's a homestead? No, I'm just kidding. But that's how the essays make you think. If you see a house, a lot of processes to go. It's so cool. What about inter vivos? Well, what's that?
Inter vivos is just the opposite of a testamentary. It's just created during the settler's lifetime. So you have to remember, you can create a testamentary trust during your lifetime, but it won't become in effect until until you die, basically, because it's a part of a will. And inter vivos trust happens during your life. So this is the instance where you are a millionaire, you have this knucklehead nephew that you want to give money to right now. You want to give him the classic example I always give to people is you win the lottery, and you don't want these blood-sucking relatives that you have to come after you every 10 seconds for more money. So what you might do is you build 5 inter vivos trusts. You give them all $100,000 or something, and you say, I want to talk to you ever again about money. Here's your payout. Here's what I'm giving you forever. And so, for instance, it's created during your lifetime. And this is one of those instances where you're going to have to talk about whether it's revocable or irrevocable. When you see an inter vivos trust, to decide whether it's revocable or irrevocable, because the settler is still alive, right? So the settler might have the option to revoke it. And like we talked about, if it's not said, it's going to be assumed it's revocable. And we talked about oral a little bit. And then actually, this is the actual rule. I don't know why the rule over there is on the last slide is incorrect. But yeah, only valid if not for real property or less than $500. So what that means is an oral trust. If I tell you I'm going to build a trust for $1,000, then that trust is valid because I have intent, I have beneficiary, I have as long as I say who the trustee is, that oral trust can be valid in the state of Florida. And like Andrew said, I think he said it briefly, that is a very specific to Florida rule. A lot of other states don't allow that. You can mention, maybe add 1 point, 2 points, if you say that, Florida has a rare exception to many other states that they allow oral trusts in this jurisdiction. No contest, very simple, not valid in Florida. So no contest trust is a trust in which you say, and we talk about this in no contest wills, right? Where you say, contest this trust. If you say this trust is not valid for whatever reason, if you sue the trustee, then you lose all claim to the property in the trust. That's not valid in the state of Florida. You have to be able, you are allowed to contest trust in the state of Florida. And then charity does not need to have specific beneficiaries. It must be for public purpose and for public at large. Rule against perpetuities does not apply to charities. I would not advise you to go into a deep rule against perpetuities analysis on trust essays, unless they're really, throwing that in your face. It's not going to be worth your time most of the time. However, if you see a charitable trust, just throw this sentence on there, get 1 point, talk about it just a little bit. And now finally,
I could give him a second point there. Does anyone know what will happen if a trust is supposed to go to a charity, but that charity no longer exists?
So we're gonna get to that.
Sorry.
That's okay. Do you want to go over it now, or do you want to?
No, I don't want to take away your thunder.
So that's at the end at modification. But we'll talk about that. Don't worry. So and then the last one is support. It's used to support a beneficiary. Newsflash: 99% of trusts are going to be support trusts. So this is a great one to learn, to memorize, right? Because you can throw this on to 99% of the trust essays you're ever going to get, and then that's 1, maybe 2 points that you get that everyone else doesn't get because it's so basic and stupid, they're going to forget it. So yeah, I would highly recommend just memorizing these words, and my trust essay, I mentioned every single one of these. And literally, I saw it was a trust essay. I immediately just wrote down Trissy Donks on my sheet of notepaper, and then I said what all of Trissy Donks was. I wrote next to it, testamentary, resulting, revocable, all that stuff. And then I went ahead, didn't read the facts. I went ahead and just wrote a paragraph about what each of these things were. And then I read the facts, and I went back and said, in this instance, this is a testamentary, spendthrift, discretionary, no contest. What all those things mean. These other things don't apply, but they're important to know. Blah blah blah. Even if it's not the facts of the case, facts of the question, you're still going to get points for knowing what a resulting trust is. You're still going to get points for knowing what a charitable trust is. And maybe not as many points. You don't want to spend too much time on it. You don't want to spend on it. But just throwing in the word a charitable trust does not need a specific beneficiary for whatever reason. Just throwing in one sentence, that can be so much more points compared to what other people are getting. So very important to know the specific types of trusts after you talk about whether the trust is valid or not.
Right. So what Will's saying so far is literally doesn't matter what it is. You see an essay that has trust, you're doing his acronym was valid trusts don't ruin marriages, right?
Yep.
Valid, the first thing is the validity. Is this trust valid? Can someone remind me what the elements are of a valid trust? See if anyone's listening.
You need a settler with intent to create a trust. You need trust res, so property that is actually in possession, ascertainable beneficiaries, trust a valid purpose.
Legal purpose, yeah.
Sit tap. Which one am I? I'm missing one, right?
You said a trustee and ascertainable beneficiaries?
Yep. Oh, that's what I missed. I was missing a trustee.
Yeah, trustee. And
Yeah.
who can serve as, well, I guess you didn't, did you just say that? Who can serve as a trustee?
I don't think we got there yet. Did we?
Yes. I won't go through it. So it's 18 of over 18 and Florida resident.
Yes. You're right. We did.
Cool. So identify, is there a valid trust? And you could be yes or no, but literally 98% chance there's gonna be a valid trust created. You can argue maybe it should have been writing, maybe it wasn't, but just for the sake of the essay continuing, it's probably gonna be a valid trust, but go through it. Here, there is a settler with intent. Tommy was a valid person. There is a trustee who's 18 and a resident of Florida. Brandon is that person. There is rest. The property is the money. Go through all the elements. Then you get to this piece. What type of trust is it? The next issue is what type of trust it is. Trissy dunks. That's why I love Will. These are all the different types of trust. This is a very quick definition of all of them. Here we likely have an irrevocable discretionary trust that has spendthrift provisions, right? It's you start with the umbrella. I mean, this is a tough umbrella. This is a word dump, but the thing about trust is it's not that bad. If you can just dump it and move forward, it's actually relevant to the reader because you're telling the reader, all the different types of trust. You're considering what it is and what it isn't. It's this one. So far so good, right? Everyone knows identify has a valid trust been created, and then what type of trust is it? We're good with all that?
Yeah, just one thing. So something that I guess that I heard you just say, and I heard Will say a little bit before, that I had a little bit of trouble, I guess, understanding that with these types of trusts, with Tristy Dunks, you can have a it'll be a revocable discretionary, you know what I mean? Like it can be all of those things. It'll be a revocable trust with discretionary whatever, and it's also a support trust. Can be all of them.
Testamentary, irrevocable, discretionary, spender
Right.
trust, sure. And then some other things, because I love pushing for greatness. I don't know if you're going to talk about this. Are you going to talk about the secret S's, Will?
No, you can talk about that. Yeah.
Okay, so there's a secret trust and a semi-secret trust. Does anyone know the difference between them? Which one is valid and which one's not?
It's the secret is and the semi-secret's not.
And where do they occur? A semi-secret versus secret?
Right. They pop up in a will, essentially, right? Within a testamentary trust.
Right. Right. The semi-secret trust is not mentioned in the will, and the secret trust, no, the semi-secret trust is mentioned in the will, and the secret trust is not mentioned in the will, right? Let me look this up so I don't say the wrong thing to the class, or someone else can look this up for me.
Got it somewhere.
A fully secret trust is where the existence of a trust is not mentioned at all in terms of the documents. The will is completely silent as to the existence of the trust, and that will fail. Whereas a semi-secret trust is a type of trust where a will mentions a trust, but does not specifically name any beneficiaries or is unclear about the specific terms of the trust. Thus, it is semi-secret because only part of the trust is written in the will. However, key provisions are left out. Okay, I want to clarify that in all of our own minds. It's okay, we're learning here. Secret trust is just not mentioned in the will. How would you ever know about it? That's not valid. A semi-secret trust is mentioned. Like a secret trust is like, wait, Tommy created a trust for me. It's like, bro, it's not mentioned in the will. It's not valid. A semi-secret trust is mentioned in the will, but it doesn't say who the beneficiaries are. So then it would be left up to the probate court or someone to determine the beneficiaries because it was their intent. Remember this sentence. The hallmark of trust creation is settler intent. Whatever the settler wanted to do, we're going to try and make happen. So those were two things that I was trying to get brownie points for. Semi-secret versus secret trust. And I remember Will's way of making me memorize it was like Tristy Dunks, and then there's a silent S at the end because of secret. Oh no, there's a secret S at the end, secret, silent, whatever. And then the other thing is, I don't know if you talk about this, Will, but honorary trusts?
No, it's not. It's not. Yeah, go ahead.
Okay. Does anyone know what an honorary trust is? Because it's very near and dear to my heart. Does anyone know what that is? Joel, you're shaking your head?
Yeah, that's when you create a trust for your pets.
Yes, of course. Very important. Honorary trusts are valid in Florida. We are a very pet-loving state. All right, perfect. So we got the, is the trust valid and what type of trust is it? And try to remember these things, not too much, but if you can do a sweeping statement on is it a valid trust and what type of trust is it, you're doing really, really well.
So does anyone want to remind me what comes next? Does anyone remember from the acronym?
Valid trusts.
It's the D. What's the D?
It's good you got the D.
I know.
Yeah, it's the D though. I just looked at it. Oh, okay, duties. Duh. Trustee duties.
Duties. Valid trust don't. So the don't for duties. All right, let's hear. This is important. What are the duties of the trustee? Very important.
Let's go ahead and get them all on there.
Violated in the essay. They always violate their duties. Always.
And this is what Andrew and I talk about. I mean, they're literally every essay is going to be the only things they can test about, right? So like, they almost always violate these things. So the acronym for duties is FLIPS, which I think is a fun sound to make with your mouth, FLIPS. And I had to physically stop myself from making that noise on the exam day. So prudent investment, loyalty, personal, and separate. So prudent investment just means make prudent investments. I mean, it's pretty self-explanatory. Can't be too aggressive, can't be too weak. But there's a presumption of prudence when they advise an expert. So 9 times out of 10, the trustee is going to be a bank. And they're making prudent decisions. You know, banks aren't too aggressive, banks aren't too weak with their investments. They're probably putting in bonds, honestly, or property. But so that's fine. But sometimes there's that, you know, one out of 10 times where you make Joe, your family lawyer, the trustee of your trust. And Joe, your family lawyer, is not a multi-conglomerate banking organization, so he doesn't really know what he's doing. But if Joe, your family lawyer, goes to his accountant and says, "Hey, is this an okay thing to do with this trust?" and the accountant says, "Yeah, that's fine," then there's a presumption of prudence. Prudent investment does not mean that the investment came out well. You put all of your stock in Disney right before they decided to screw over Scarlett Johansson or whatever happened, and then their stock plummets, and then you get scared, so you pull all your money out. That doesn't necessarily mean that it was a not prudent investment, right? Disney at the time was probably a pretty good investment, a safe investment. It's not your fault that the market didn't shape out. It means you have to remain loyal to the trust. And the way this always shapes out is Joe, your family lawyer, is the trustee for this trust, and the comes on the market, and the property comes on the market that would be perfect for the trust to purchase. It's the exact kind of thing that the trust, you know, thinks about, talks about, and so Joe, your family lawyer, however, really wants that property too, and so he buys it first. That's not allowed. The trustee has to give first dibs to the trust when it would benefit the trust. And it also means self-dealing with the trust is not allowed. So that means you can't make Joe, your family attorney, can't make his wife the secretary for the trust and then pay her a salary from the trust, right? You can't do that. That's self-dealing. He's making money from the trust because of his position as a trustee. You just have to do the work of the trust personally. You can't just like ship it out to a you can't just be like, "Oh, I'm not dealing with this. I'm the trustee, but someone else is going to do it entirely." But you're allowed to consult an expert. So that's pretty easy. Separate. You're expected to keep the res of the trust separate from other property. It's very important. This is one of the most hotly tested subjects. I feel every time I read an essay, I'm always reading this. So Joe, the bank knows this, right? The bank has 1 million bank accounts and they're keeping everything separate. They know what they're doing. But Joe, your family lawyer, only has 1 or 2 bank accounts, right? And so you give Joe, your family lawyer, $1 and you say, I want to make a trust out of this. Please make a trust out of this. For this and this reason, good to go. And Joe's like, cool. And he just goes and deposits in his personal checking account. And maybe he does keep a tally of like what the trust has, but the money itself, the property in the trust, is mingled in with his other property. That's not okay. The res of the trust must be separate from other trusts. Banks do get in trouble for this when the property they invest the money with other monies into investment accounts. So investment accounts are one of the biggest issues here too. When a bank pools all of the money from all of their different clients together and they invest it in one lump sum into one big investment, that can be a problem for keeping the trust property separate. They want to make sure there's always one lump sum of money that says this is what the trust actually is. They do some funny accounting things to make it happen, but they want to make sure they keep it separate legally. Any questions about these duties?
No, I like this. Plus, prudent investment, loyalty, act personally, and to keep the funds separate, not to commingle. Very easy. Trust essays. We're praying for a trust essay. First, is there a valid trust? You know, did they have the necessary elements? Go through each one of them. Here, they do or they don't. What type of trust is it? Mention on the trust, and then, you know, say which type of trust it is. And then always, the issue is whether Max violated his duties as a trustee. The duties of the trustee are the prudent investment rule, the duty to act loyally, the duty to be personal, and the duty to keep trust funds separate. Talk about what each one of them are, and then he probably violated 2 of them. That's what we're looking out for. And also I told you the spendthrift thing and whether, you know, who could pierce and who couldn't pierce. But so good, right? Like, is it a valid trust? What type of trust is it? What are the duties? Valid, trust, don't. And then the R is coming up, right?
Anyone tell me what R is? Okay, if you can't.
Ruin,
Removal.
it is. But
You said removal.
I'm also the number one seed in the whole NFC. It's removal, right? Perfect.
So removal, and this is the easiest one. Literally, plagiarizing problems on the bar. These two sentences. The removal of a trustee can happen for any serious violation of a duty they owe to a trust. So if you see any of these being violated, then point blank. You can also remove the trustee when their services are so seriously unsatisfactory that they would be doing a disservice to the trust to keep them in place. So if any of these duties are violated to a serious degree, they can be removed. Joe, the family attorney, is just really bad at his job. Like, maybe he's doing all these things fine, but he's just really bad at it. To be better at it, then they can remove them. And so the first one is really a legal issue. You know, like, you're going to go through these duties. Did he violate these duties? You know, that the second one, though, that's more of a discretionary role that the court has. You can, you know, petition a court, hey, this trustee is doing a really bad job. Can you please remove him and replace him with this person? That's going to be a discretion that the court can have if they can say that it's seriously unsatisfactory and a disservice to the trust. Easy stuff.
Awesome. And I know a big statement to use on the essays. Well, first and foremost, IBIS Prep does not support any instance of plagiarism. We're 100% against that. He just meant that he probably copied this from, you know, some model answer.
Well, no, I made this up. I'm saying you can plagiarize it from me, but you can plagiarize is the right word. You can.
Well, it's the better word
take
to
it.
use, to be fair, is memorize. It's okay to memorize the rule and then to recite it precisely. That's in fact what we preach. So here, the removal of a trustee can happen for any serious violation of duty they owe to the trust. He just went over all the duties. Does anyone, without looking back, remember what PLUP stands for? Anyone? How about
Prudent investment, loyalty, which is the duty of self-doing. The P is personal and service.
And S stood for what?
S is personal and is it service?
Separately, to separate.
Separate.
Commingle funds. Excellent. Right. So I know that it's easy for Will to memorize and maybe me because I've been doing this for so long, but make sure when you're listening, you're testing yourself as you move forward. Do you know don't is for duty? Valid is for valid. Trust is for trust. Don't is for duty. Ruin is for removal. And there's a key statement here, which is a trust will not fail for want of a trustee. Does everyone know what that means? Is that in your PowerPoint anywhere?
It should have been under the trustee.
But it's all the same.
I suppose it's not, yeah.
We can remove the trustee can go disappear, whatever. The court will put someone in for a trust that will replace the trustee, because the purpose of the trust is not for the trustee. The purpose of the trust is for the beneficiaries and for following through with whatever was the settler intent. So pretty solid. So valid trust, don't ruin marriages. What does M stand for?
Modification.
Nice. Let's check.
Yeah. So and so the acronym for modification is WIC. Favored, but less so than termination. So they don't want to change the trust, but they'd rather change the trust than terminate the trust entirely. So charitable trust has the Cypress doctrine, which is what Andrew was going to touch on a little earlier, but we'll get into that. So there are the reasons that a trust will be modified are WICs, and so it's waste. Does anyone know? This is actually, we'll test real property real quick. Does anyone know the 3 types of waste in real property?
Like the back of my hand.
Ameliorative waste, affirmative waste, and I can't remember the other one.
So it's ameliorative, permissive, and
and affirmative.
So remember, I usually flip them, but yeah. So affirmative is just waste, just straight waste. You're destroying the property, whatever. Permissive is allowing the property to fall into disrepair. Usually, a lot of times, is by taxes. Remember the 4 or 5 P's: pay. And ameliorative is when you're improving the property, but it's changing it in a way that some of the remaindermen don't want you to change it. So waste is, so that was a real property thing. Waste and trust is different. Waste is really just affirmative in this case. And so in this case, in the fulfillment of the trust would create waste. So if you're basically just throwing money away, then you can change the trust. And so this is kind of a classic example. Back when polio was was a really big deal, a whole bunch of trusts were created to support the polio vaccine research. And after the vaccine was discovered, all those trusts suddenly were just throwing money into a fire because they already had the vaccine, right? So they had to change the way that thought about these trusts and change how they went, where they went. So very important. That's one of the reasons you can modify it. Second is illegality. So one of the past example where there were a bunch of segregationist trusts, trusts that were supporting parks, but only if they were whites only parks. And so when it was outlawed, they had to change these trusts to remove these segregationist clauses from the trust. And finally, the last one is change circumstances. So this is when the circumstances have changed to such a degree so as to make it necessary for a modification to occur. Classic example, and this is like straight from the case law, is a billionaire newspaper mogul made a trust that supports the newspaper that he owned, and after he died, several years later, his family petitioned the court to change the trust because that newspaper was failing, and they wanted to change the stock from that newspaper to some other more profitable business. So when he created the trust, that newspaper was really, really profitable. And now it's not that profitable, so the investment in that property is no longer great. I'll be honest, waste and change circumstances are going to look pretty similar a lot of the time. I mean, you'd be hard pressed to give me a reason why this polio example wouldn't also work in change circumstances. So both arguments, right? You want to say all three, and then the last one is satisfaction. And this is the exact same thing as waste. So the trust for in this polio example was made, we'll go through the actual example. So if the trust was created to make a park and the park was made, well, then the trust is done, right? And they have to make something else for the trust to do. Waste, change circumstances, and satisfaction are going to look very similar a lot of the time. There are many examples in which all three of them will look exactly the same. You just want to say all four, all down on the paper, and then just make a decision. Say why you think that one is more likely to be that one, and then, or say, in this instance, it's all three, whatever you want to do. It doesn't really matter what your conclusion is. It matters you get the right analysis leading up to the conclusion. So make sure you're doing that. Illegality obviously is kind of the black sheep. It definitely looks the most unique out of the four. And then the last thing we need to talk about is the Cypress doctrine, which Andrew wanted to talk about a little bit earlier. But so when a charitable purpose selected by a settler is impractical, the settler and the settler general charitable purpose, the court will select an alternative charity when that charitable purpose is no longer necessary. So this goes back to the polio example. The Cypress doctrine would probably apply to these polio trusts. Basically, the trustee wanted to help society in general. He wanted to eradicate polio. Then polio was eradicated, and the judge then had to say, okay, we're going to pick a similar issue. Now we're going to look at I don't know, Ebola or something, like another illness that is very similar that's going to affect kids, whatever, what have you. We're going to try to eradicate that illness now. And then there's this, which is just a straight memorization issue. You just memorize this sentence and say it. I doubt very seriously that this kind of thing is actually going to be tested on that's a very minute detail, but just throwing in a sentence like that point is very easily memorizable. It's kind of such an obscure thing that very unlikely other people are going to be writing about it, except for the 6 people that are in this room, because we're all going to be here. We're learning about it right now. Any questions about modification?
No, that was pretty awesome, man. So we have valid trust don't ruin marriage. We go through whether the trust is valid. That's the main thing. That's the main part of a trust analysis. Make sure you go through all the points. Is there settler with valid intent? Is there a legal purpose? Is there trust race? Are there ascertainable beneficiaries? And is there a trustee? And the trustee has to be 18 and a resident of Florida. And then we go into what type of trust is it? TRUSTS acronym. Remember, testamentary. It's got to be written because it has to comply with will formalities. So it's tested by 2 subscribing witnesses and the like. Big ones of TRUSTS are the revocable versus irrevocable. You know, they're presumed revocable in Florida. Definitely know the spendthrift provisions. And do you talk about spendthrift provisions anymore here?
Not anymore here, no.
Does anyone know who can pierce the spendthrift provision?
Oh, yeah.
Anyone out there? That's an important thing.
So you can
Child support,
so
can.
Go ahead. Child support is one. What else? There's one.
Alimony?
Right? Alimony, child support, or
Yeah, the government tax claims.
government taxes, same that can pierce the homestead, right? So that's what pierce the spendthrift provision. So just kind of look out for that because trust and family law could connect. Do you have any other more slides, or this is pretty much it?
no, this is it, yeah.
Perfect. Awesome timing. Look, when this afternoon, we're going to go back over trust. I'll go over my outlines and stuff a little bit quickly to complement this, but we're going to spend the 3 hours this afternoon looking at trust and family law essays and putting this to practice. But you'll see what Will just provided us with. Valid trust don't ruin marriages. And if you can know if is a trust valid, what are the different types of trusts? What are the duties of the trustee? Can someone please remind me the duties of the trustee? PLUPS, right? What does PLUP stand for?
Prudent investments. They must act personally. No commingling.
Mhm.
So I'm not going in order.
It's fine.
They must be loyal to the trust.
And personable, right? Separate, personal, loyal, and prudent. And then, okay, so valid trust don't ruin the removal. We can remove for all these conditions. Will, can you just remind me what were some of the conditions for removal? Not all of them, but what were some of them?
It just if you violate a duty, you can be removed, or if you are acting so unsatisfactorily that it would be a disservice to the trust to keep you in place.
Right, valid trust don't ruin marriages, and then modifications. And one of the cool things about modifications was that Cypress doctrine, where we'll choose another charity. Waste, illegality, change circumstances, satisfaction. That was really, really good. I make sure you understand what the spendthrift provisions mean, that you can't pierce it. There's certain people who can, spousal, child support, and government taxes, and just kind of anticipate recognizing those things and irrevocable versus revocable. But overall, trust essays are easy. We're going to see them this afternoon when we go through the essay, and we're going to bring Will back in just 10 minutes to teach us about family law. Now, I'll tell you, family law is a little bit harder. I'm trying to reclaim the host because I want to show everyone something. Oh, yeah. So I can reclaim the host. Family law is a little bit harder. I'm going to take a 10-minute break, but before we do that, I just want to show you that my team is always hard at work, and look what we've already come up with. My own album cover, Ill-Gotten Gains Restitution, and this is how it comes in CD form. So we want everyone to come up with something really proper like that. You'll never forget that ill-gotten gains are to disgorge. I mean, restitution is to disgorge ill-gotten gains. Yeah, look at that picture. That was cool. That was back when I was cool. But anyway, let's take a 10-minute break. We'll come back at 1:02 and we'll do family law. And we're just going to jump right into it. Will, you going to be ready to rock and roll?